Ask a few questions. I'd love to be able to ask all of you questions. I just don't know if I have time. Let me start with Ms. Mastel. Did I say your name?
Yes, that's correct.
I want to be sure I understand. Judge Kavanaugh coached your daughter,
Yes,
and his daughter wasn't on the team at that time?
correct.
And when he finished coaching the kids, at the end of the season, he wrote them all personal notes?
Yes, a detailed evaluation of things to work on, things you did well, and then the final note, which is what I read.
Does he generally do that for his teams, or do you know?
I think he does it for everybody on the team, for every team he's coached.
Okay. I want to switch gears. I think I heard Professor White and Professor, is it Heinzling, my apologies, talk a little bit about transfer of power from Congress to the president, and I'm thinking of it in terms of the Chevron doctrine. And I'd like you to each quickly help me out with this. Here's my problem with the Chevron deference. I just don't understand how it's constitutional. And here's why. I look at the APA, which of course Congress passed, and Congress says this is the law, the reviewing court, not the agency, the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. That's a statute, 5 U.S.C. Section 706, as I'm sure both of you know better than I do. So how can the courts construe that congressional directive as giving the power to an agency? That was clearly not Congress's intent. Could you each give me about 30 seconds on that?
This is a great question, and it's a puzzle in administrative law a little bit. The text of the Administrative Procedure Act says what you say it says, and has been sort of hidden from view in a way for a number of years. But I think the answer would be that even where a court defers to an administrative agency on the interpretation it's offered, it's still making the legal judgments, the relevant legal judgments. It is deciding, in the first instance, is the statute so clear that it shouldn't defer at all? And in the second instance, even if the statute isn't clear, it's making the judgment about whether that interpretation is permissible.
So if I could, not to interrupt you, but
Yeah.
I have to keep us on schedule.
That's fine.
So you think that Chevron deference is unconstitutional in your
No, I think it's consistent with the language of the Administrative Procedure Act. I don't think it's unconstitutional, no.
Okay. Professor White.
One of the interesting things about Chevron and its relatively short history is that you've had critics and proponents on both sides of the aisle. The most eloquent case for Chevron's constitutionality and propriety came from Justice Scalia in a 1989 Duke Law Journal article. That said, there's been an increasing awareness, I think, on both sides that in the biggest cases, Chevron deference illustrates either a delegation of judicial power to an agency or it respects a delegation of legislative power to an agency. That's why you see, I think most recently in the King v. Burwell case, where Chief Justice Roberts with Justices
Stop you, Professor.
well, with Ginsburg, Breyer, and others set aside Chevron.
Right. Okay, I got it. You've helped me a lot there. Professor Mascott, did I say it correctly?
Yes, Senator.
Did you ever see Judge Kavanaugh take politics into consideration in deciding a case?
No, Judge Kavanaugh spent his time learning the record inside out, looking at the law, statutes, and precedent.
But you were with him a year?
Yes, sir.
You never saw him take
No.
politics, ever?
No.
Not once?
Nope.
Okay, fair enough. Mr. Clement, should the Supreme Court televise oral arguments?
Well, that's an excellent.
Could you turn your mic on?
That's an excellent question.
I've only got 42 seconds.
Sure. I think that's an excellent question. It's a question that I think the justices are ultimately going to have to answer at some point unless Congress forces its hands by passing statute. And then there'll be a very interesting question whether that statute is constitutional. My own view, for what it's worth, is that televising Supreme Court arguments makes an awful lot of sense. It's one of the odd realities that everybody seems to think that until they become a Supreme Court justice. and then they tend to have a different view. But as I sit here as a Supreme Court advocate, I honestly don't see a particularly compelling argument why the public shouldn't get to see the proceedings televised. And I think if they did, they'd have a very high opinion of the Supreme Court of the United States.
Well, I appreciate that. You're a hell of a lawyer. All right, I let Senator Hirono go over, so I'm going to go over 20 seconds. Mr. Dean, I don't care about your politics. I really don't. I have friends on both sides of the aisle. Like Senator Blumenthal, I remember vividly the early 1970s as well, when you worked in the White House. I think you and your co-conspirators hurt my country. I believe in second chances, but you did the right thing ultimately. But you only did it when you were cornered like a rat. And it's hard for me to take your testimony seriously. And I'm going to give you a chance to respond. But I couldn't sleep tonight if I didn't tell you that. I'll give you a chance to respond.
The president has also called me a rat, and I don't think you understand.
I'm not calling you a rat, though, in the sense of your what you did with the prosecutor. That's not what I mean. But I honestly feel that way as an American. I think you hurt our country.
I wrote a book based on all the Watergate conversations that were secretly recorded, learned a lot that I hadn't known. Out of the 1,000 conversations that Nixon had on Watergate, I was involved in 39 of them. I think every conversation I had with him, I'm trying to warn him, alert him, find out how much he does know or doesn't know. I tried internally to end the cover-up. I didn't succeed. That's the day I think I met Richard Nixon. I didn't know the man, hadn't had dealings with him. There's a great misconception about what a early 30s White House counsel could do around a White House. So maybe you'd want to, I'll send you a copy of that book, and it might give you some insights into what really did happen in there.
Okay. All right. Well, we're done. I want to thank this panel very much. I'm going to say what I said to the earlier panels. I know this testimony doesn't just write itself, and you all spent a lot of time on it, and I really want to thank you. I think all of us get a lot out of this part of the confirmation process.